Hi everybody, Armine Bazikyan here from Bazikyan Law Group. Today I wanted to speak to you about probate. What is probate and why do we talk about it when speaking about death? So probate is actually a legal process. It's a court procedure, and what it allows us to do is take the assets of a person that has passed away and actually transfer them to their beneficiaries or their loved ones, their family essentially, or friends. So how does the probate process actually work? Well, in California, which is what I'll be discussing today, if you pass away with a will in place, you will have to have your estate will have to go through this probate process. If you pass away without a will in place, it will also go through this process. So in both these scenarios, you have to have your assets funnel through the probate court in order to get to your family. And so one of the ways that we avoid this process is by creating a living trust in place, or a revocable trust, which is a term you might have oftentimes heard. So that's the loophole in the system. But today I want to speak about just the probate system. What happens if you don't create any type of plan, or you create kind of a, at-home will or just a simple will. So once you have to funnel your estate through this process, you have to seek the assistance of an attorney because it is a very complicated process. And how does it actually work and how does it start? Well, let's say that Dan passed away and he had created a simple will, and this fact pattern will be similar regardless of if he had created a will or not created a will. But let's just assume that he had created a simple will and he had named his daughter as the person in charge. So what would happen at his death is his daughter would take the original of the will and she would begin a probate case or petition the court to be appointed. So a probate case would effectively come to life. What would happen is she would file for the probate and the petition would go into the court system, and the court system would monitor everything that she does until she gets to the point where the estate is ready to be distributed. So she would petition the court to be appointed as the person in charge because that's what her father wished for, and the court would review the documents and say, yep, that's what he wanted, we're putting you in charge. The court would actually give her the authority, give her the appropriate paperwork to go out into the real world and actually deal with the banks that he had accounts with, his real estate, whatever assets that he might have owned. So once the person becomes appointed as the person in charge of the estate, they can actually start doing things. They can go to the bank and get the money out. They can, effectively talk to people, will actually speak to them now because they will be the court-appointed person. So once they're appointed, they will usher the assets in, meaning they will collect all the assets, make sure it's insured, take care of it, do everything that they're supposed to do to make sure that they preserve the assets. And during this process, they will provide what's called notice to certain people. So all of his heirs at law, for example, would get notice, all of his people named in his will would get notice, and also all of his creditors would get notice. So there is a notice requirement where anyone, basically what she would be saying is, hey, if you're a creditor and you're out there, come in and let us know that my dad owed you money so that we can pay you. And so there's a claim period for creditors to be able to come forth and make a claim for money that was owed to them by this individual that passed away and get their money back. So once this creditor period is over and once most of the assets, everything is kind of settled in, she can then actually petition the court to close down the estate. And in order to do that, she does have to provide an accounting oftentimes to the court, depending on certain circumstances. So what essentially is happening is the court is actually monitoring the entire process. They're actually looking in and making sure that everything she did was appropriate, it was proper, she didn't commingle funds, she didn't steal anything, she didn't do anything improper. Once the court has reassurance that she has done everything correctly, they will give her the green light to actually divide everything and distribute it the way that the person wanted it to be distributed. Meaning, if the house was supposed to go to his son, she would create the paperwork that would transfer the property to the son. So once the court gives the green light, the person in charge can actually wind down or close the estate, and the probate is effectively done at that point. So it's a very tedious process from beginning to end. It's a very convoluted legal process, and it's extremely difficult to navigate the probate court system nowadays. On average, the probate case or an average probate let's just take a simple case for example. It takes about 9 months to about 2 years to complete from start to finish, depending on the court's calendaring system and what happens with the judge that you're assigned and whatnot. So it's a very, very lengthy process, and it's extremely expensive. The probate court system tells you how much you're supposed to pay your attorney. So it's a statutory fee that you're paying your attorney, and it's based completely on the amount of the assets that are in the estate. So, for example, if all you had in your estate was a house and it was valued at $500,000, the probate fees alone will be around $13,000, and the court orders you to pay this before anything can be done. And it's done all the way at the end. So you don't pay your attorney any fees to help you throughout this probate process. They get paid at the end when everything is distributed. So it's a very, very expensive process. There's costs associated, which can run anywhere from $200 to $3,000. So it's a very expensive process when you're comparing it to the actual estate planning process. You know, had Dan actually gone out and created an estate plan with a living trust to avoid probate, he would have saved a tremendous amount of money. So this is oftentimes 3 or 4 or 5 times what it would cost to do the planning ahead of time. So it's a very expensive process, and it's extremely time consuming and lengthy. And the part that a lot of people don't like is the fact that it's a public process. Everything that you file, all the information you provide to the court is open to the public, so anyone can come in and access that information, which not a lot of people like. So it is a convoluted and difficult process to navigate through. You definitely need the assistance of an attorney, and our law firm is equipped to handle these types of cases. So if you do have a probate matter and you have some questions that you want to ask, feel free to contact us and we can consult you on it. We do provide free consultations, so you can go ahead and give us a call and we'll schedule a time for you to come in and give us all the details, and we can help you out more personal to your situation. Thank you. Bye-bye.